good afternoon to everyone joining this webinar. Depending on where you are joining us from, we're absolutely delighted to welcome you to Phil Fisher's inaugural Privacy, Security and Information webinar. And what better topic to be talking about today than the new EU-US Privacy Shield. Now, if you're a follower of European privacy, you may be forgiven for thinking that the European Union is single-handedly trying to deforest the Amazon at the moment. A few months ago, you'll have been hit with 200-odd pages of the General Data Protection Regulation to familiarize yourselves with. And then more recently this month, you will have seen the 128-odd pages of the Privacy Shield that's come out. Now, the good news is that we're trying to take some of the sting out of that for you by having digested the Privacy Shield. And the goal of today's presentation is really to move the conversation away a little bit from some of the more complex areas of the Privacy Shield around the national surveillance regimes and the rights and wrongs of security surveillance, and focus much more on the actual business impacts of the Privacy Shield. In particular, trying to answer that question that everybody wants to know the answer to right now, which is, should you or should you not certify under the Privacy Shield? Now, as the webinar goes on today, we will be delighted to take questions. We're running a fairly tight ship. We have an hour to get through all of this. So there is a questions box in the little control panels you should see for the Citrix GoToWebinar. If I can ask if you have any questions, if you put those in there as we're speaking. And then when we get to the end of the webinar, depending on the time we have, we'll do our very best to answer those questions. If there's any we run out of time to answer, we'll try and follow up with you separately. Now, in terms of the agenda for today, let's see if I can advance that. These are the topics we're going to be discussing. I'm delighted to be accompanied by three very knowledgeable and experienced colleagues. I have with me Felicity Fisher, who's an associate in our Silicon Valley office. We have Yuli Takatsuki, who is a legal director, also working in our Silicon Valley office. And then Olivier Proust, who works in our Brussels office. And all of them have been working very closely and very intensively on Privacy Shield matters very recently. So the agenda for today, we're going to just start off with a little bit of background. First off, talking a bit about how did the EU-US Privacy Shield come into existence. To understand why the Privacy Shield is so important, it's important to understand a little bit of the background that led up to it. Then we're going to look at some of the key differences between the Privacy Shield and the old Safe Harbor regime, which I'm sure many of the participants on today's webinar will have previously been certified under. We're then going to look at the all-important question of what do companies who want to certify under the Privacy Shield actually need to do, and how do they go about that. And then finally, we're going to ask the all-important question, is the Privacy Shield right for your organization? So with that introduction, let me hand you over now to my colleague, Felicity Fisher, who is going to talk you through a little bit of the background to the Privacy Shield. Flick, over to you.
Hi, morning everyone. Hi, so I thought we'd start with a quick recap of the European data export rules. So for everyone on the call, Article 25 of the European Data Protection Directive broadly prohibits the international export of European personal data outside of Europe to international recipients unless that recipient has implemented adequate protection for the data. There are a number of kind of restrictions or other ways in which you can justify the transfers, including relying on the consent of the individual or contractual necessity. But these restrictions are generally very narrowly interpreted and in practice don't really apply very successfully for routine commercial data transfers. So the end result is that recipients are required to implement a data export solution that has been approved by the European Commission. Next slide, please, Phil. So up until October last year, one of the most popular solutions for US data importers was the Safe Harbor framework. As most of you on the webinar will know, this was a self-certification scheme adopted by the US Department of Commerce and approved by the European Commission in July 2000. And it effectively required US data importers to commit to comply with the 7 Safe Harbor principles and therefore commit to protect European personal data roughly to European standards. However, in October last year, Europe's highest court, the European Court of Justice, declared the safe harbour framework invalid, and overnight those US companies that had relied on certification were forced to look to alternative means, which effectively were, in practice, the binding corporate rules or model clauses. Next slide, please. So following the European Court's opinion, there has been a kind of race for the EU and US to agree a new framework to replace safe harbour. However, the process had in fact begun well before the European courts got involved. In fact, since its adoption, safe harbour has been fraught with challenges and criticisms from European data protection regulators. Indeed, as early as kind of June 2010, German regulators had sort of passed resolutions kind of announcing that they didn't like the safe harbour framework and encouraging German companies not to rely on it. But really, the clock really started ticking in June 2013 when the Snowden revelations about mass surveillance carried out by the US National Security Agency on EU citizens really brought the issues to light and gave it a kind of headline, made it a headline topic. In the wake of those revelations, the European Commission in November 2013 issued a communication to the European Parliament and the European Council effectively calling for the scheme to be reviewed in light of the Snowden revelations. And they kind of acknowledged that the safe harbour framework, which had been approved in kind of 2000, really hadn't foreseen the large-scale data access by US intelligence agencies, and therefore, and then they issued a kind of 13 recommendations for the improvement of the scheme. And then in March 2014, the European Parliament got involved and indicated its dislike of the framework by voting to suspend it. It didn't actually have the competence for that to be effective. There's a real kind of public statement about what they thought about the safe harbour. At this point, safe harbour was kind of bruised but still intact. And then kind of cue Max Schrems, the famous Austrian law student, on a personal kind of privacy crusade. And he, hot off the heels of the Snowden allegations, alleged that Facebook Island was forwarding data to the NSA via Facebook's Californian headquarters, and started to take action through the Irish courts to review the adequacy of the safe harbour framework. The matter was heard in the Irish courts in June 2014 and was ultimately deferred up to the European Court of Justice for them to review. Essentially because the Irish courts determined that it kind of concerned a matter of fundamental European law. And so the European courts were asked to determine whether or not the safe harbour framework still was an adequate transfer mechanism. And then on the 6th of October 2015, there was a much publicised ECJ decision which effectively declared the safe harbour framework invalid, an invalid data export mechanism, amongst other things, because the EU courts thought that the Commission had not ensured that the safe harbour decision addressed the massive and indiscriminate surveillance of EU citizens by the US public authorities. And this was considered kind of fundamentally incompatible with European privacy rights. So although the Snowden revelations got things kind of to the headlines and kind of really got the clock ticking on the siege against safe harbour, it really had been bubbling away long before that. Next slide, please. So after the safe harbour framework was declared invalid, frantic negotiations began to try and find a solution. And the very next day, the Article 29 Working Party kind of issued a statement basically saying that the EU and US authorities had until the end of January 2016 to come up with a workable solution, therefore sort of giving them a 3-month grace period to get the negotiations going. And then kind of 31st of January came and went, and then in the 11th hour on the 2nd of February, the European Commission issued a press release and issued its kind of draft adequacy decision on the 29th of February for the Article 29 Working Party and others to review. So really, to get it over the line, it now needed to be reviewed by the Article 29 Working Party. It needed to be approved by the Article 31 Committee, which is representatives of all the different member states, and then it needed to be formally adopted by the Commission. So during the next 4 months, there was a number of statements issued by the Article 29 Working Party and the European Parliament, all of which kind of indicated that they weren't happy with the draft adequacy decision and the draft documents. So we were all kind of concerned that actually it wasn't going to get over the line. Principally, their issues, they had a number of issues, but they really felt that the framework, the draft framework, didn't really meet the test or for adequacy, which was essentially that it needed to be essentially equivalent, provide essentially equivalent level of protection to that of EU data protection law. However, after much toing and froing, and despite the negative opinion of the Article 29 Working Party, the Article 31 Committee did finally approve the final version of the Shield on the 8th of July, and the Commission formally adopted it on the 12th of July, which came as kind of welcome relief to a number of people, I think. Next slide, please. Next. So what does the Privacy Shield look like? Well, as Phil mentioned, it's 128 pages, so it's a bit of a beast of a document, and it really contains the Commission's adequacy decision, and then it lays out the Privacy Shield principles and details of the new kind of arbitration model in Annex 2. And I think those are the two key documents that really, if you're looking to read through the Privacy Shield and tackle it, those are the two documents that I'd recommend reading. The rest of it really contains official letters from the US government officials providing assurances around the legal limitations affecting access to personal data by the US government agencies, and are worth reading if you're interested in all the kind of national security issues. So with that, I hand over to the next speaker.
Thank you, Flick. So with that now, I'm going to pass over to Olivier. The good news, as you will probably have gathered from the webinar so far, is that of those 128 pages, it's really Annex 2 that you need to be reading very, very closely. And Olivier is now going to take you through how the Privacy Shield differs from the previous safe harbor regime. Olivier, over to you.
Thanks, Phil, and hi everyone on the call. So essentially what I want to do in the next couple of slides is walk you through some of the similarities and especially some of the key differences between Safe Harbor and Privacy Shield. This is really, I guess, one of the questions a lot of people are asking themselves is this Privacy Shield really that different from Safe Harbor? Next slide, please. In many respects, the Privacy Shield does look like a Safe Harbor rebooted. As you'll have understood from the previous presentation that Felicity just gave, the legal basis for the Privacy Shield is this adequacy decision that was just issued a few days ago by the European Commission, and that is based on a political agreement between the European Commission and the Department of Commerce, which was already the case under Safe Harbor. The purpose of this Privacy Shield remains the same. Essentially, it's enabling European-based companies to transfer personal data to the United States and to comply with the European data export restrictions under this Article 25 of the directive. This is something that is going to continue to exist under the General Data Protection Regulation, by the way, because data export restrictions will generally remain the same. So this is not something that will change under the GDPR. The scope of the Privacy Shield is also similar to the Safe Harbor in that it applies to any American organizations that fall under the jurisdictions of the Federal Trade Commission and the Department of Transportation. So all of those companies are eligible to participate in the Privacy Shield program. Some companies are excluded, namely the financial institutions, telecommunication carriers, airline companies, and non-profit organizations. The Privacy Shield is operated in a very similar manner to Safe Harbor. It is administered by the US Department of Commerce, so in that sense nothing changes, and it's based on a voluntary self-certification program, so companies will have to certify on the Department of Commerce website, which, by the way, has recently been updated, but the DOC will be taking certifications only from the 1st of August, so in a few days from now. Enforcement is carried out by the Federal Trade Commission and the Department of Transportation, respectively. So in that sense, that remains the same. And finally, the privacy shield, the way it's interpreted, and verification of compliance with the privacy shield principles is carried out under US law. So although the privacy shield program is meant to comply with restrictions under EU law, its interpretation is carried out by US organizations under US law. Next slide, please. So although there are some similarities, the privacy shield does look like a safe harbor on steroids, in that there are some very significant differences, a lot of aspects of the former safe harbor framework that have been significantly reinforced under the privacy shield. First of all, something that's important to highlight is that it applies now to controls and processors. This is something that was not clear under safe harbor. Now it's clearly stated under the privacy shield program, and this is important given the huge development of service provider companies in the past years, and a lot of companies that previously falling under the safe harbor program were not sure whether they could certify or not. The privacy shield principles are roughly the same as those of the safe harbor program. I'm not going to go into detail of those now because my colleague Yuli is going to run you through those in her presentation in a few minutes. And essentially, one of the key things that is different under the privacy shield is the role of the Department of Commerce to provide information about companies that have certified. The DOC has to make publicly available a list of self-certified companies, which is called the Privacy Shield list, on its website, and also has a duty to update this list annually whenever companies recertify or withdraw from the program, or when they are removed by the Department of Commerce. The DOC also has to keep a record of companies that have been removed and explain why that was the case, and provide a link on its website to enforcement cases that are being carried out by the Federal Trade Commission. There's also a lot more that is expected from the Department of Commerce in terms of oversight and verifying that organizations are effectively compliant with the Privacy Shield principles. So the DOC has a duty to verify that privacy policies and statements made by organizations effectively comply with the Privacy Shield principles, that personal data is returned or deleted once companies are no longer on the Privacy Shield list, or if they retain the data, that they continue to do so in accordance with the Privacy Shield principles. The DOC will monitor websites to verify that there aren't any false claims or misrepresentations, including by former members. So this is not just the members that are on the list, but also members that are no longer certified or that have withdrawn, and that may continue to state in their online privacy statements that they are certified. So this is something that the DOC will have to monitor. The DOC can also carry out ex officio compliance reviews of certified organizations, for example by sending them questionnaires, or simply when it receives a complaint from an individual. And finally, one of the new aspects of the Privacy Shield is a possibility for the DOC to remove companies whenever they fail to comply with the Privacy Shield principles, or for example if they fail to recertify in time to the Privacy Shield. Next slide, please. So one of the key new elements of the Privacy Shield framework is also the redress mechanisms, and the least that we can say is that individuals now really have multiple possibilities that are offered to them to exercise their rights and to make complaints. And this was really one of the key issues that was discussed during the negotiations, to make sure that individuals could effectively file complaints. So there's a sort of logical way to do this. Obviously, individuals can complain to the organizations that are certified to the Privacy Shield program, and this requires now such organizations to respond within 45 days and to have an internal process in place that allows them to handle effectively complaints that they receive from the individuals. The individuals can also complain to an independent dispute resolution body, which is located either in the United States or in Europe, and that is designated by the organization itself. And information about this dispute resolution body has to be provided in the privacy policy that is posted on the organization's website, so that people know how they can contact this body. The national data protection authorities are also much more involved than before, in that organizations must cooperate with a national DPA whenever it has voluntarily submitted to the oversight of such DPA. But this oversight is obligatory in cases of processing that concerns employee data, so in the employment context. So the individuals can also complain to their national regulator in their home countries. Complaints can also be made to the Department of Commerce. The way it works is that individuals will typically complain to their national regulator, and then this will be channeled to the Department of Commerce through a dedicated contact point. Also, the Federal Trade Commission can accept complaints directly from individuals, and will also be reviewing referrals that it receives either from dispute resolution bodies, or from the DPAs, or from the Department of Commerce. And then, as a last resort, and this is one of the new elements that has been created under the Privacy Shield, is this so-called Privacy Shield panel, which essentially is a pool of 20 arbitrators that are designated by the Department of Commerce and the European Commission. And that will also take any complaints from individuals and review them in a similar fashion to an arbitration body. So the decision that is issued by the Privacy Shield panel will be enforceable before the American courts under the Federal Arbitration Act. Next slide, please. And of course, the Privacy Shield does go a lot further than Safe Harbor, and there are some key new elements under this Privacy Shield framework. The possibility for companies to voluntarily withdraw from the Privacy Shield. The Privacy Shield panel, which I just mentioned a minute ago. Clear limitations on access and use of personal data by U.S. public authorities, which was mentioned earlier by Felicity, so I won't come back to this in a lot of detail. I'll focus instead on the remaining bullet points. The Privacy Shield ombudsperson, which I'm sure you've heard of, and which also the negotiators, the Privacy Shield, spent a lot of time discussing the role and how this ombudsperson will be set up. Essentially, this will be a senior coordinator in the State Department at the level of the Undersecretary. And this ombudsperson provides an oversight mechanism specifically for national security interference. So it's kind of separate from the other redress mechanisms that I just discussed in the previous slide. One of the elements that the European Commission wanted to make clear in the adequacy decision is that the ombudsperson has to be independent from the intelligence community. So this will be the case. And essentially, this ombudsperson will serve as a contact point for foreign governments whenever they want to raise concerns regarding U.S. signals intelligence activities. And so it will handle complaints that are addressed by individuals to supervisory authorities in the member states in Europe. Another new element is the annual joint review mechanism. Essentially, from a general point of view, the European Commission will carry out periodic checks to verify whether the adequacy decision it has issued is still factually and legally justified. There's very clear wording now in the adequacy decision about this, and the fact that the European Commission is going to continuously monitor the overall framework, including once the General Data Protection Regulation comes into force. And in particular, the European Commission is going to pay particular attention to verifying compliance by US authorities with the representations and commitments that they have made and that you can find in the different annexes. But also the adequacy decision will be subject to an annual joint review mechanism which will cover all aspects of the privacy shield, including the operation of the national security and law enforcement exceptions under the Privacy Shield program. And this will be done through regular meetings with the Department of Commerce, the Federal Trade Commission, and representatives of the Article 29 Working Group and the National Data Protection Authorities. And so on the basis of this annual joint review, the Commission is going to prepare a public report, which it will submit to the European Parliament and the Council of Ministers here in Europe. And the United States has committed to inform the European Commission of any material developments under US law that are relevant to the Privacy Shield. So as I mentioned, the Commission will assess the level of protection provided by the Privacy Shield on a continuous basis and following entry into force of the GDPR. The role of the national data protection authorities is significantly increased under the Privacy Shield framework. They have the power to exercise oversight whenever they are designated by an organization, but in all cases when employee data is being transferred, they have a clear obligation to review complaints that they receive from individuals in their home countries. And they now have the possibility, and mechanisms will be put in place allowing them to refer complaints to the Department of Commerce and the Federal Trade Commission. Finally, they can suspend transfers of data to the United States if they have any reason to believe that the certified organization is not complying with the Privacy Shield, and this they can do under their respective national laws. And finally, the European Commission has the possibility to suspend its adequacy decision. It can initiate this procedure, for example, if there are indications that US authorities are not complying with the representations or commitments that they have made, or if there is a failure to effectively address the complaints that are addressed by EU data subjects, or if the Privacy Shield ombudsperson fails to provide responses to individuals in a timely manner. So in such situations, what the adequacy decision states is that the European Commission will first inform the Department of Commerce and request that appropriate measures are taken to address these issues within a given time frame. But if the Department of Commerce fails to do that, then the European Commission will initiate procedures that can lead to either a partial or a complete suspension of its adequacy decision, or ultimately it can decide to repeal its decision. So essentially these are the key differences and similarities that I wanted to highlight. So with that, I'm going to pass it on to Yuli for the next presentation. Thank you.
Thank you, Olivier. So lots of new stuff to look out for in terms of differences from the previous safe harbor regime. What we're going to do now is just take a little bit more of a deeper dive into some of the principles of the Privacy Shield and specifically how you go about certifying. So with that, I will pass over to Yuli.
Thanks, Phil, and good morning from California, everyone. I'm going to be outlining what companies need to do from a practical standpoint to certify under the Privacy Shield. So to recap, there's 7 core principles that companies have to comply with under the Shield. In addition to that, there's further guidance which pads out some of those requirements, and they're referred to as the supplemental principles. And as Felicity said, it's those texts together, which are what all companies certifying to the Shield will need to become familiar with. And that runs to around 30 pages of text, but it's fairly digestible and easy to read. So I would certainly recommend that as a starting point. The core principles are, by label at least, broadly the same as those under Safe Harbor. So organizations that were previously Safe Harbor certified will be relieved to a certain extent to hear that the differences between the 2 regimes, practical requirements, aren't vastly different. So companies won't have to wipe the slate clean and start from scratch on their compliance. So let me delve a little deeper into what each of the principles requires. Okay, so if you look at the slide, the first one is notice. Now this concerns adding certain prescribed information into your privacy policies about the Privacy Shield. And I'll just note some of the key requirements, and a lot of this will probably already be in your privacy policies already. So it's obviously your participation in the Shield and your commitment to adhere to the Shield's principles, the types of personal data you collect and the purposes for which you collect them, the type or identity of third parties to whom you disclose the data and the purposes for which you do so, how to exercise an individual's right to access their data, and how they can make complaints. So as Olivier outlined, not just through the organization, but through the independent dispute resolution mechanism you choose, at the regulators, and eventually through the binding arbitration scheme. So there'll be a little bit of tweaking to privacy policies that will need to be done, but hopefully not a wholesale rewrite at all. So moving on to the second principle, which is choice. This is very similar to what was previously required under Safe Harbor. Organizations have to provide individuals with a way of opting out of disclosures to third-party controllers, and also when information is used for a materially different purpose. Under Safe Harbor, it was actually incompatible purpose, so it's been bolstered a little bit to materially different purposes. And you need to provide a conspicuous and readily available mechanism for opting out. So you will need to call that out in your privacy policy and explain how that can be done. Now, if you're doing either of these things for sensitive personal data, you now need to seek express prior opt-in consent. So moving on to the third one, which is onward transfers. Now, it's probably one of the slightly more onerous requirements, so I'll go into a little bit more detail here. This principle requires certain terms to be included into your contracts with third parties to whom you disclose the data. And there's 3 key terms that they would like you to incorporate into your contracts. The first is that the data is only to be processed for a limited specified purpose consistent with the original consent, not particularly controversial. The second is that they provide the same level of protection as the principles. And the third is that they must notify you if they can no longer meet that obligation. Now, there is a question of how this second requirement to provide the same level of protection as the principles, how that requirement can be satisfied. It's obvious that if the third party themselves are Privacy Shield certified, that's going to satisfy that requirement. What's not clear is, for example, how the model clauses interplays with this. So in other words, if the third party who you're contracting with isn't Privacy Shield certified, but you already have model clauses in place with them, we don't know if that will count as providing the same level of protection as the principles. Common sense would dictate that it should, but we don't have confirmation from that, on that from the regulators yet. And given that the requirements are slightly different under the model clauses to the privacy shield principles, our advice at this stage would be to err on the side of caution and make sure that your contracts expressly call out compliance with the shield's principles. One sweetener that the Department of Commerce has offered in relation to this principle is that companies signing up to the shield within the first 2 months will be given a further 9 months from the date of certification to comply with this principle. So you will at least have that extension of time to carry out those third-party negotiations and reprocurements. And perhaps during that time we'll have a little bit more clarity around how the model clauses interacts with this. So moving on to the next slide, the fourth principle is security. So this is just a very generic one. It's the usual requirement to take reasonable and appropriate measures to protect from loss, misuse, and unauthorized access. So there's nothing more specific than that. So it's something your information security team will need to advise you on and make sure their data handling policies are modern and state-of-the-art and so on. The fifth principle is data integrity and purpose limitation. This one says that personal data that's held must be limited to that which is relevant for the purposes of the processing. So in other words, you're prohibited from over-collecting information. So just make sure that you're always keeping an eye on the information that you're holding and that it's relevant for what you've said you would use it for. Organizations have to take reasonable steps as well to ensure the data is reliable, accurate, complete, and current. It might be difficult in practice, but having a good data retention and data deletion policy in place will help you to demonstrate that. The sixth principle is access. So this is, again, very similar to what was required under Safe Harbor. It's the right of individuals to subject access, which is the right for them to request a copy of all the personal data that you hold about them, and also a right to correct, amend, or delete that information if it's no longer accurate or relevant. Now, the way it differs to the EU right to subject access is that US companies don't need to provide this right if the burden and the expense of providing that access would be disproportionate to the risks to the individual's privacy. So that's a little carve-out which will be useful to organizations, but you will need a subject access policy in place before you certify, just to make sure that your staff can recognize subject access requests, be trained to deal with them or to direct them to the right person. Next slide, please, Phil. So the seventh principle, now Olivier's already outlined this in some detail, so I won't go back into it. Just to remind you that this is a tiered complaints handling framework in essence. So it gives the individual 4 layers of complaints procedure that they can go through to find recourse for any problems. So that's one component of this principle. The second component is what's called verification. In other words, it's what you need to do in the years ahead to stay certified. And some of these are a little bit onerous, the same as Safe Harbor, but I imagine now the enforcement will be stricter. So firstly, you'll need to remember to recertify every year to the Department of Commerce. And secondly, organizations must carry out annual assessments in-house or through a third party to verify that you're completely implementing all of the principles and you're continuing to comply. So just make sure you have those procedures in place to trigger that every year. And we all know how quickly a year passes before it comes around again. So next slide, please, Phil. So I'm just going to end by providing a broad summary of what I think are the key compliance steps for companies. And I've hopefully crystallized it into 5 main steps. This is the upfront work that I think is required before self-certification. The first is updating your privacy policies to ensure compliance with the notice principle. The second is to revisit your contracts with third-party controllers and processors and amend them if necessary to include the specified terms. The third is drafting some internal policies around subject access requests, complaints handling, and data retention and deletion, if you don't have those already. The fourth is to sign up to your independent recourse mechanism, whether that's your third-party dispute resolution provider or submitting to the jurisdiction of the European DPAs. And finally, the fifth is to make sure you have those procedures in place to conduct the annual compliance assessments and recertifications in the years ahead. Just a final note on the actual process for certification. The Department of Commerce is going to start accepting certifications from the 1st of August. It's likely to be an online process on the website attached to with a small fee. You'll need to get a corporate officer to certify a number of things and to submit a number of documents, and then you'll be certified from the date of your submission. So that's it from me. Back to you, Phil.
That's great. Thank you very much, Yuli. So hopefully that's been a useful sort of canter through for everyone so far about where the Privacy Shield came from, how it differs from the previous safe harbor regime, and specifically what the Privacy Shield requires and how, what you need to do in order to prepare yourself for certification. Now, the next part of the webinar is really just to discuss whether the Privacy Shield is right for your organization, and to give you what are, I'll be honest, very personal thoughts from me around this. Now, just before I do that, I'm going to have an attempt to launch a poll that we have got for on this webinar, which is just to get a current measurement of people's intentions about whether or not they're planning to participate in the Privacy Shield or not. Now, because I'm a data protection lawyer, I will tell you that the poll is entirely anonymous. It is just an opportunity for you guys to participate and to just kind of see the kind of results about how you are all feeling about the Shield. So let me have a go at launching that now. Now, hopefully you should see that poll up on the screen. I'll give you just a few minutes just to, well, not a few minutes, I'll give you a few seconds to click on a few buttons. And then I will share the results of the poll as well, so that you can see how everyone's feeling about this. Be some interesting results here, I think. Okay, so I'm going to close the poll in 5 seconds. 5, 4, 3, 2, 1, and let's close it now. So now hopefully I'll be able to share you the results of that, and hopefully you can see those all up on the screen. So interestingly, what you'll see from this is that at least of the attendees that are on this call, almost a whopping 50% are on the brink of saying that yes, they are going to participate in the poll. There's around sort of 10% saying no, and about sort of 40% or so who are in the not sure bracket. So quite an interesting statement really in terms of how people are feeling. Clearly there's a strong incentive for a lot of our US attendees on the call to want to participate. So let me resume the slideshow again and hide that. Oops, so daisy. Here we go. Right, hopefully we've got the slides back up on the screen. So is the Privacy Shield right for your organization? Well, in sort of answering that question, I feel a little bit like John Cleese in Life of Brian, sort of asking, what have the Romans ever done for us? In this case, it's what will the Privacy Shield do for you? And really, it depends on who you speak to, because if you listen to Jan-Philipp Albrecht and Max Schrems, Jan-Philipp Albrecht being the German MEP who led a lot of the negotiations from the European Parliament angle on the reform of the, on the General Data Protection Regulation, the reform of European data protection law, you will see that his view on this is really quite damning. He says, given the countless insufficiencies, it is otherwise highly likely that the Privacy Shield will share the history of the previous safe harbor and be invalidated by the European Court of Justice. Not a huge statement of faith, and if you're a business that is planning your future on the Privacy Shield, then it doesn't fill you with sort of warm and fuzzy feelings. On the other hand, you have the Commission Vice President for the Digital Single Market, Andrus Ansip, who said that we've agreed on a new strong framework on data flows with the US. Our people can be assured that their personal data is fully protected. Very bold words there. And our businesses, especially the smallest ones, have the legal certainty they need to develop their activities across the Atlantic. Do they, though? And that's really the question. So what I want to look at is just some of the pros and the cons of pursuing the Privacy Shield. Now, I think one of the really important things to bear in mind, if we start with the pros, the advantages of the Shield, is that for a very sizable number of companies, the Privacy Shield is really the only data export compliance solution that's available to them. And I've got a couple of diagrams in a second that will illustrate this. But in essence, if you are a US company without any if you're a US consumer-facing company without any of your own operations in the EU and no sort of counterparty data exporter in Europe that you can sign model clauses with, or who can be your entity in Europe for the purposes of your binding corporate rules application, if you're wholly US-based and you're servicing European consumers, then really the Privacy Shield is the only way you can comply with European data export laws. And so there's a very strong incentive for those types of companies to want to pursue the Shield. There is also the huge competitive aspect of it. You know, whatever the goods and bads of the Privacy Shield, it is a badge in the same way that, you know, having a trustee symbol on your website is a badge. And you can guarantee, particularly if you're on the supply side of the world, that your competitors are going to be adopting it. I think, you know, in recent days we've already seen sort of Workday and Microsoft have come out and said that they're going to adopt it. Amazon, I'm sure, has probably said the same. And if you're an in-house privacy bod, there's a good chance that your sales team are banging on your door right now and telling you that you have to adopt the Privacy Shield because it's fundamental for closing contracts. So you have a lot of pressure to want to adopt it just on a pure commercial aspect. Now, the nice thing about it is that you know, it is, for the most part, if you're a US council, it's mostly enforced by a known entity regulator. You know, you are going to be primarily answerable to, you know, a combination of the Department of Commerce and the Federal Trade Commission, or possibly the Department of Transport. You're not going to have such direct exposure to European data protection authorities as you might if you were to go down the model clauses route or the binding corporate rules route. Now, if you've been paying attention to the presentations earlier, then you will know that if you're transferring HR data under the Shield, you have to submit to the oversight of the European DPAs, or you might voluntarily choose to do so anyway. So, you know, it's not to say that the European DPAs don't have a hook into you if you go down the Shield route, but you do get a bit more comfort in that you are dealing with a regulator you know and whose activities you have perhaps more familiarity with than you do on the European side of the pond. One of the really big advantages of the Privacy Shield is also that it is a self-certification mechanism, and that is a huge advantage over something like binding corporate rules. Much as we love them at Field Fisher because we do a lot of them, the binding corporate rules process is an approval process. You have to submit stuff to the regulators. If any of you have gone through that process, you will know that it takes a good chunk of time to get through. Whereas the Privacy Shield, by comparison, self-certification sounds nice and quick and relatively easy. It's going to be kind of self-certification plus because the Department of Commerce has said that it's going to take a greater level of interest now in the certifications that are made to it and actually verifying that people are living up to the promises that they're making, but it's still going to be a lot easier than doing something like binding corporate rules. Now, again, if you're on the supply side of the world, one of the really, really attractive aspects of the Privacy Shield is that it doesn't contain a couple of the nasties that the controller to process and model clauses contain. All of those of you who have, you know, watched Safe Harbor collapse in October and then went through some kind of massive re-procurement exercise with your customers who are, you know, getting you to sign controller to process and model clauses, and then you've been trying to flow them down to your own vendors. One of the challenges, you know, with those negotiations is that is this consent right for appointing sub-processors. So under the model clauses, if you are a processor and you want to appoint a sub-processor yourself, the clauses say you need consent from your customer. And if you're a shared platform, the idea that you may go back and speak to all of your customers to appoint a new vendor that's going to service all of them is just a complete non-starter. Now, the Privacy Shield doesn't contain that nasty for sharing sort of ordinary personal data with agents. So that's one of the big advantages of it. The other is that the Privacy Shield doesn't give your enterprise customers any audit rights over you. Again, very controversial under the control to process and model clauses. They do contain an audit right. If you read it, it reads very much like an on-site audit right, and data processors are typically very reluctant to sign up to that. The Privacy Shield doesn't have that, meaning that any audit rights that you are subject to are simply going to be those that you have agreed as part of your service terms and conditions. And then finally, there is this 9-month grace period. What is that? Well, as a kind of sweetener to encourage people to join the Privacy Shield, it basically says that if you join in the first 2 months from the effectiveness of the Privacy Shield, then you get this kind of 9-month period in which to sort out your subcontracting chain. Because if you remember, the onward transfer principle under the Privacy Shield basically says that there are certain terms you have to put in place with third parties with whom you share data. Now, that entails another reprocurement exercise, and I am imagining that there's a lot of you who went through the model clauses exercise that aren't really have much of a stomach to go through it all over again. But the sweetener in the Privacy Shield here is that it says, look, we know this will take some time, so if you sign up to us early, we'll allow you 9 months to sort that out. And so, you know, there is that kind of grace period, and that is as an incentive. What are the negatives, though? Well, the biggest single negative, or 2 biggest single negatives to my mind, are the first 2 bullets on this. The first is that there is a huge amount of uncertainty about the Privacy Shield. There's been a lot of rhetoric. The European Commission has told us it's great. The Department of Commerce has told us it's great. But data protection authorities seem yet to be really convinced by it, and civil liberties organisations certainly seem to that they have yet to be persuaded that it's going to be any good. To be fair, it's hard to imagine that there's much that will keep some of the civil liberties organisations happy, but what seems an inevitability about the Privacy Shield is that it is almost guaranteed to be challenged. And so we can probably expect at some point we will hear that there'll be a legal challenge mounted against the Privacy Shield, and it will generate the same kind of uncertainty that's existed with Safe Harbour. There is also the effect of the Schrems ruling, which was effectively to say that DPAs can now investigate whether or not they think the Privacy Shield is good enough in individual cases with specific companies. And so the fact that you've signed up to the Shield doesn't necessarily mean that the data protection authorities are just going to buy that you are now good enough. You know, Germany, your German DPA may still decide to investigate and say that in your case, he doesn't think the Shield is good enough and you have to use model clauses. So the Privacy Shield is far from certain as a guaranteed compliance solution. The other big negative to it is that if you are a supply-side company, there's a good probability that your European customers will still want you to sign model clauses with them, at least for the short term, because of all that uncertainty that exists around the Privacy Shield. They're not going to be convinced that it's going to be a reliable solution, and so odds are that if you go into negotiations, they will say, well, it's great that your Privacy Shield is certified, but we still want you to sign model clauses as well. So it may not solve your problem. Remaining points, well, the FTC came under a lot of criticism under Safe Harbour for not doing enough to enforce it. You can expect that it is going to be under intense pressure to show some kind of enforcement under the Privacy Shield. It has already indicated that it will treat Privacy Shield complaints as a high priority, and so there may be 1 or 2 test cases to come, and nobody likes to be a test case. Of course, depending on the number of people that sign up, the odds of being that test case may be very, very slim, but we just don't know how the FTC are going to react. There is also this joint annual review mechanism, which Olivier and Julie have both talked about. The real concern there is just simply that we don't know how the Privacy Shield may change over time. The Privacy Shield that you sign up to today may look very different in 12 or 24 months' time, depending on how the European Commission and the Department of Commerce choose to evolve it through that mechanism. And then there is this whole issue about what is meant by the same level of protection in the onward transfer mechanism. If you're sharing data with other controllers or with data processors, with your agents, you have to make sure that they provide the same level of protection. Now, and the supplemental principles to the Privacy Shield support this. It doesn't necessarily mean that they have to be Privacy Shield certified, but it doesn't really make clear what the same level of protection is. And that leads on to the next bullet, which is that the interplay between the Shield and the model clauses is very, very uncertain. And really what's needed on that point is some guidance from the regulatory community to say, yep, if you share data with a party that has signed up to model clauses with you, we think that will be good enough. But at the moment, we just don't know. And so while that uncertainty persists, you may still want to just continue to rely on model clauses. So what are the situations where the Shield works well? Well, here is the first example of that. I mentioned it at the outset. You have a consumer company in the US, Consumer Co. Inc. It is servicing a bunch of European consumers who are all in member states in the EU, and they're sharing their data across the Atlantic to the consumer company. Now, that company doesn't have anybody in Europe that it can sign model clauses with, because consumers don't sign model clauses, and it's got no exporting subsidiary or counterparty in Europe that it can sign model clauses with, so model clauses aren't an option. Binding corporate rules also ain't an option because it doesn't have an entity within Europe that can submit the application to the authorities in the EU. So the only solution it is left with is the privacy shield. So for these types of companies, the privacy shield is a bit of a no-brainer because it is just something you have to do in order to be compliant. What about the next scenario? Well, the next one is this one, where you are a global company and you have your own subsidiaries in the EU, and the data that you want to transfer is your own data. It's your own HR data or your customer records management data. Now, in those cases, you've got a couple of options there. Actually, sorry, there's a cross next to binding corporate rules. There ought to be a tick. You could do binding corporate rules there. That would be one option. But if you're looking to move quickly, binding corporate rules may not be the option for you right now. Now, you could certainly sign model clauses. You would, as a minimum, have to sign 3 model clauses there, one from each of the subs to the parent, or possibly one set of model clauses with each of them as signatories to those model clauses. But the Privacy Shield might provide a nice solution here, and the reason it might do is that all that data is only going to the US. It's your own data. It's not customer data, enterprise customer data that you're sending, so you're not going to have enterprise customers asking you to sign model clauses because they don't trust the shield. So you can kind of rely on your own shield certification to transfer data up to the US. And in that case, again, the shield might work quite well. Where it doesn't work so well is this particular situation. Now, in this case, what we have again is a global company, but this time it's got subsidiaries in the EU. It's US headquartered, but it's also got a subsidiary out in India. And the data here is going to the US, it's going to India, possibly even going between the European subsidiaries. Now, Privacy Shield doesn't really work here, or at least it doesn't work well for the international transfer aspect of it, because it won't cover the exports that are going out to India. If you adopt the Privacy Shield, it will only solve the solution, the exports that are going to the US. So in this case, you would be looking to implement something like an intragroup agreement that incorporates the model clauses, that enables the data to flow around the group, or possibly as a more robust and longer-term solution, you might adopt binding corporate rules to enable the free movement of data anywhere between your group entities. And then this is the other situation where the Privacy Shield doesn't work so well. This is the custom scenario I was explaining. So here you have a European Union customer on the one hand saying, hello Mr. Supplier, I'd like you to process some data for me, but I notice you're in the US. How are you going to comply with the EU data export rules? And odds are the supplier's sales team will turn around and say, hi Ms. Customer, we'd love to help you, and don't worry about those EU data rules because we're Privacy Shield certified. And I've witnessed this kind of thing in negotiations so many times with Safe Harbor as the uncertainty unfurled, and I expect it to continue with the Privacy Shield. I expect the European customers to turn around and say something like this. I've heard of the Privacy Shield, but my data protection officer doesn't like it. He says it may be declared invalid like Safe Harbor. We'd like you to sign model clauses or have process of BCR. So in that case, you may have gone through the whole Privacy Shield certification only to find that your customers won't tolerate it, at least in the short to mid-term until there's some more certainty about the long-term future of the Privacy Shield. So with that in mind, in that particular context, the Privacy Shield may not work so well, at least for now. So in summary, the Privacy Shield may be a good choice if you have no EU data exporter with which to sign the model clauses, or your subs are transferring their own data to the US parent and you don't have some enterprise customer that's asking you to sign model clauses with it. In those cases, the Privacy Shield may be a good choice. It may not be such a great option if you engage in wider international transfers, because you're going to need to sign model clauses anyway, so why have 2 solutions when you could just use one throughout the entire group, or you could do the binding corporate rules. Or you're transferring your customers' data, in which case there's a very strong likelihood they will still want you to sign model clauses, or they'll still want you to have BCR, and they're not going to trust Privacy Shield for the immediate future. So that brings me to the end of the presentation part of our webinar. What I would like to do now is just to deal with some of the questions that we have coming in. We're almost on time, so I hope you'll bear with me while we deal with a couple. Livia, let's maybe just take one for you to begin with. So we have a question from one audience member who picked up on the reference to the Article 31 committee in some of the opening slides. Can you just explain what the difference between the Article 29 Working Party and the Article 31 committee is?
Yes, of course, and this does get confusing, especially for well, I'd say both for people outside of Europe and even for people within Europe. Essentially, the Article 29 Working Party is this regulatory body at a European level that is composed of representatives from each of the national data protection authorities. So in every EA member state, you have a national data protection authority, and they sort of all gather for regular meetings in Brussels under this sort of European group that is called the Article 29 Working Party. And you also have representatives of the European Commission and the European Data Protection Supervisor, who are members of the Article 29 Working Party. So essentially that's representatives of the DPAs, the Data Protection Authorities. On the other hand, the Article 31 Committee is a separate group composed of national experts who are appointed by the European Commission specifically to review and assess the compliance of a proposed adequacy decision with European law. So in this particular case, the European Commission would have appointed national data protection experts who spent a few days or a couple of weeks reviewing the proposed adequacy decision and then issued their opinion on that. So that's the difference between those two groups.
Thanks, Olivier. And we've got one other question that's come in here as well, asking for the early registrants, what date is the 9-month grace period calculated from? And I'll take that answer, and Olivier, feel free to correct me if you know otherwise. But the short answer to that is that we're still waiting to find out. There's a little bit of uncertainty around that because the Privacy Shield was adopted earlier this month on the 12th of July as an adequacy decision. But it doesn't actually come into effect until the 1st of August. Now, there are two schools of thought of this. One is that the two-month period runs from the point that the European Commission adopted its adequacy decision around the Privacy Shield. I personally don't think that's the right one because it would lead to a very odd result if you lose a month of that period simply because you're not eligible to apply, for that intervening time. So my guess is that the 2-month period will run, the 9-month period. The 2-month to submit, allowing the 9-month grace period, will run from the point that the Privacy Shield is actually open to applicants, which would be the 1st of August. We had one interesting question here coming in about treatment of key-coded data under the Privacy Shield, saying that under Annex 2 of the Privacy Shield, key-coded data is excluded from its application, and can we offer any insight into this? I suppose the answer to that is simply going to be that, and this refers to one of the supplemental principles of the Privacy Shield, which deals with key-coded data. And essentially, for those of you who are from life sciences organizations on the call, what happens is that if you are conducting some kind of clinical trial, typically the institution that is running the trial will encode that data, and they will hold the key to that encoded data, and then they may transfer that coded data out to the sponsoring pharmaceutical company out in the US to analyze the results. Now in that case, the key doesn't get transferred, only the key-coded data. And what the Privacy Shield said is that key-coded data is not treated as a transfer that needs to be covered by the Privacy Shield because it doesn't treat it as a transfer of personal data under the Shield. It's quite an interesting explanation there, because I'm not sure that's the way that European data protection authorities would necessarily treat it. Typically, even if data is key-coded, some of the European DPAs at least would still see it as personal data even if the recipient didn't have the key. But at least for the purpose of the Privacy Shield, that's what it says. Let me see what else we have coming in here. One question around the submission process for the Privacy Shield, just asking what documents other than your privacy policy will you be required to submit to the Department of Commerce in order to certify? I don't know if Yuli's still with us, but Olivia or Yulia, I don't know if either of you want to take that, or if not, I will. Shall I take that one?
Feel free to. Sure, go ahead.
Sure. So principally for the Privacy Shield, the main thing that you have to demonstrate is that you have a compliant Privacy Shield policy. If you are If you're having your Privacy Shield certification extend to HR data in addition to sort of your customer data, then you may also need to submit a separate HR Safe Harbor Privacy Shield policy. HR Privacy Shield policy in addition to your customer Privacy Shield policy, because one of those is going to be more of an internal-facing document. One of them is going to be an outward-facing document. In addition, you will need to provide some evidence that you have actually verified your compliance with the Privacy Shield standards. So I think you'd be looking for some kind of internal assessment, or if it was conducted by some kind of third party who conducted the assessment, maybe some third party assessment report. And then there is just a general sort of cover letter that you need to provide with your application, which sets out certain factual information about your organization and the data that's being covered under the scope of your Privacy Shield certification. So those would primarily be the three things that you would need to certify: the Privacy Shield policy itself, the means by which you verified your compliance with the Shield, and also your letter to the Department of Commerce setting out your application and the factual information they need. Now, there are more questions we've had coming in. I'm just conscious that we've run over time and people have things to run off to. So if I can thank everyone who has submitted questions and just let you know that we will endeavour to follow up with you individually if we haven't had the time to answer them on the call now. Equally, you've got all our contact details on the screen up here. Do feel free to email any of us with your questions. And separately, you may also find it interesting to come and visit our blog. We also have a feed on Twitter that you're welcome to follow. And I will circulate slides to everybody who has participated on this call. So we thank you very much for your time. And with that, and thank you also to the panelists who presented today. And with that, let's close it here. Thank you, everyone.